Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Well, hello everybody. I hope you are all well. As usual, late, but really, I set the time. I make it rhyme. It's Friday. That's right. Hi, Wahoo, Vicky, Sherry. I hope you guys are ready for some drama with somebody's mama, not mine or yours, hopefully. But we do have quite a juicy court case ahead of us. The title card, if you will. It's Felicia, yeah. Paisley could not be bothered doing her hair. She wants it to look like this. Oh, see, I thought in a future far, far away from my childhood that we would get to pick things like our hair and our face based upon a simple button. But we're not there yet. It's not that simple. We're the precursors. Anyways, yay, Vicky! Oh, I saw that you re-upped your membership. The best channel on YouTube. You're so sweet. You're so sweet. Let me check and see if I did my homework properly. Yeah, it works. Yay! Thank you, Vicky. So sweet. Like I said, we have ourselves quite a doozy of a case. I haven't watched it all, but I did listen to a little bit of it. I also have a bunch of other stuff that we can listen to. We will do a slightly shortened show. It is Friday night. Some of us have to have plans. How's the weather today? The weather has been shit. I've been in an, what is that called? A bomb cyclone. Don't cancel me, YouTube daddy. It's not anything really bad. It's just weather. But yes, that has been choosing nail colors with a button as demonstrated on Total Recall. That would be so cool. You know. Yeah, I'm just not that good at faces and makeup. So anyways, but the temperature here is 49 degrees Fahrenheit. Feels like 48. It's raining outside. That's pretty standard around here. It's been raining for a while. A lot of people lost power around here. I didn't, luckily. Thank goodness. But I think it's mostly back by now. Anyways, let's get ourselves going for the evening. For those of us that might have plans, let's make them happen. Whew. Okay. What am I supposed to do? Oh, yes. Click this button. No, this button. Well, I was teleported in a way over to this side of the screen. I mean, that's sort of magical. I'll give our future that. Oh, you know what really it just ill prepared me was like Clueless, right? So they made a fake closet in Clueless that I just thought was for rich people. And I suppose these days it could be for rich people, right? But I just was like, oh, something to tell me what to wear. Because I don't know what to wear. I'm terrible at choosing outfits. That's the truth of the matter. The truth of the matter asserted, Your Honor, is that Paisley is terrible at choosing outfits. Now, let's go. MB! I'm so glad you're here to see this.
Good morning. This is a matter of Campbell versus Campbell, case number 24-10930-DM. Present in the virtual courtroom, we have both parties along with their respective attorneys. We're here on the plaintiff's motion for a temporary order. Ms. Boldish-Bryan.
Thank you, Your Honor. As you know, and I know that you read our motion as well as the response, my client Danielle works part-time. The parties have one child, a 2-year-old. My client is 34 weeks pregnant. The baby is due in early January, so about 6 weeks from now. The father is a lawyer at a large law firm in town, a very prestigious law firm. There are two things that we wanted to say in response to the answer filed by Mr. Campbell. The first thing is that Danielle very much wanted to save the marriage. She didn't want to leave the marriage, even though he describes the divorce as being a mutual decision. It was not by any means. His response indicates that the parties fell out of love. And in her view, she didn't fall out of love. This is a situation where he simply left the marriage unilaterally. She asked him repeatedly whether he had an affair. He repeatedly lied to her and told her that he was not involved with anyone else. We did learn through use of a private investigator that he was involved with an affair and that his regular practice was to leave the house early in the morning, 6 o'clock, 6:30. He would leave the marital home. He'd go to the home of his girlfriend. He'd stay there in the dark for several hours. And then he would go from there to work, which was, of course, contrary to what he represented to his wife.
Oh my God. Okay, so she is pregnant and he, beside her, is the husband. Ooh, that is not good behavior. But, well, there's not a lot to defend here except that people just divorce if you don't like each other. Like, just do that. Stop fucking and having babies. Mac, yes, you are right. In fact, the AI that I generated this with, advanced AI, I used a Jerry Springer script. Handy P.
This was important to the court because we hear him now talking about his involvement with the child. Nothing could be further from the truth. He preferred and he took efforts to spend time with his girlfriend rather than the child. He did this not only in the morning, but also in the evening and also on the weekends. The second thing that we wanted to respond to is with respect to his claimed involvement with the child. My client has been able to recreate some information for me using texts from him as to where he is, whether he's working or not, based on her recollection. For example, in July, he only spent a handful of hours with her. That did increase in September to about 2 hours a week. In mid-September, he started picking her up from daycare. But the reality is that he was working, ostensibly working, on a regular basis and not returning home until the child was in bed. November 7th was the last time he even attempted to give EJ a bath. And so if you think about that, that's been several weeks since he even attempted to. It was a disaster. Child was screaming, regularly expressing preference to being with her mom, which is not of any surprise given his regular absence. It is true that he took care of EJ for a weekend in October, and I don't know how well that went, but the reality is that right now he wakes up in the morning. Now he's hanging out a little bit more. He kisses EJ in the morning and then goes off to work. Last night he spent 3 hours with her from 4 until 7. He comes home. The child immediately runs up to mom. She's crying. He had not changed her diaper. Child has a rash. Mom is trying to take care of that, does her routine. Dad is not anywhere around. He sings songs. She reads books. Again, dad's in the house, but not anywhere around. Finally, he shows up, kisses EJ goodnight, and he leaves. And then mom is left with a process of putting her down for bed. So he leaves before she even goes down to bed. Our request, Your Honor, is that clearly mom is the primary care provider of this.
Yeah, but clearly mom looks tired. Hi, MPC. Thank you so much. This is a dog fight if I've ever seen one, honestly. These are both pretty good attorneys, in my opinion. And it is getting salty right away. How did she get her hair like that? Who are we talking about? Danielle? She probably just slept like that because she's pregnant and has a baby. Hi, Sabertail. And yeah, hello, Mrs. Judd. Just wait till you hear her talk, Mikey. Just wait till you hear her talk. Oh, probably some sort of putty. I'm going to call some sort of hair putty.
Child. I appreciate dad's attempts to become more involved recently. We're glad for that. We think that a transition is appropriate in the facts of this case. We are suggesting that he move out immediately and that he begin and try alternate weekends that would include one overnight, which would be an alternate Saturday. And then additionally, with regard to his parenting time during the week, that he have Wednesday afternoons, something such as 4 until 7. I want to point out that this is more time than he has historically ever had with this child. Mom should be awarded physical.
Buddy. Thank you so much. You had a very good show today, I saw. But thank you so much. Did you see how my super chat thing glints? Because it's so special. Thank you.
Custody. That's what the facts show. Despite his claim that he has a new pattern of taking care of the child, that is absolutely not correct. We are also asking for immediate exclusive use of the marital home. The situation here is quite unique given my client's pregnancy. She's 37 weeks. This has been enormously hard on her, a very, very difficult burden. And it's not made easier by the fact of dad's practice right now to basically come in, kiss or see the daughter, and then he slams down a glass of whiskey and heads out for the evening to spend with his girlfriend. This has been very, very hard on her. He is very, very bold with regard to his relationship with his girlfriend right now. The good news is that his father has a lovely home, very lovely home, many bedrooms. He can go there immediately. Apparently, there's even a crib there. There's a high chair. It's already set up for the child. I understand that is not a long-term preferred residence for him, but it seems as though he's spending most of his time with his girlfriend anyway. So he's really looking for a temporary arrangement where he can take EJ. We would ask that he be ordered to move out of the house on Sunday. This wouldn't be the situation where he has to take all of his things out by Sunday, but he can certainly pack this weekend his clothing and personal items, move into his dad's house, and stay there temporarily until he finds longer-term housing. He has told Danielle that he's located an apartment that would be available December 1. I don't know if that is still available for him, but that is an option for him for a few days. But we would implore the court to ask that he leave the house and give her exclusive possession as soon as possible. I wanted to note that in a conversation that Danielle had with Mr. Campbell recently, she said to him, "Are you going to at least apologize for what you did?" And he said, "For what?" And it is this type of arrogance that is creating significant emotional distress for my client, which absolutely impacts the health of the unborn baby. So we need to end this now and have him move out on Sunday. With respect to the financial situation, the good news is that if you order the exclusive possession, which I expect for you to do, then we have agreed upon the terms of a status quo order, and so we don't need to address the financial situation right now. This is a very unique situation because when Danielle has the baby, she doesn't have the benefit of any maternity leave, so she has no income. That would be effective, I think, at the last week of December is when she's leaving her job for her maternity leave. So our request today, Your Honor, is that she be awarded physical custody, that the parties share legal custody, that we begin transitioning Dad's parenting time for one overnight on alternate weekends and Wednesday evenings from 4 until 7 p.m. And then finally that he move out and that Danielle be granted exclusive use of the marital home effective Monday. Thank you.
Ms. Judd.
Thank you, Your Honor. Well, as the court can gather from the argument here and from the pleadings alone, the disparity of fact in this case is pretty significant. Is he in the house pounding whiskey and not around, or is he gone having an affair? This seems to be a little bit of a moving target, but as this court knows, simply because we have an oral argument about the history of the parenting time in this case doesn't make it a reality. And my client would wholly disagree with the recount today of the history, which I've outlined in the pleading that I filed. I can certainly respect that the sympathies here lie with the plaintiff, but the inflammatory allegations about my client being a cheater and ending the party's marriage, even if they were all true, don't undermine the reality that he is a good father, as plaintiff herself has acknowledged in text messages to my client. My client would reiterate here that this marriage, again, was over quite some time ago, and he believes that Ms. Campbell knows this. Her position seems to have recently shifted when she advised my client that she would go to any ends necessary to make sure that he played as limited of a role in this child's life as possible, as well as the future child of the parties. This really is an unfortunate position that I hope is short-lived, but based on the recent allegations and the pending discovery that we have now, I fully anticipate that this court is going to be quickly placed in the position to weigh in on how much of a smear campaign is appropriate as leverage in a parenting time matter. My client shouldn't be placed in a situation where he has to gamble with job security and threats to his personal relationships with friends and family just because he wants to continue playing an active role in this child's life. Plaintiff herself has acknowledged the hurt for both parties in this relationship. I get that. She's further affirmed that the minor child is what matters. That text message was attached to my response. My client is sad too for the current state of the parties' relationship, and he wants nothing more than to keep this case limited to their child. But to that end, he is a dedicated and actively involved father, and he has no intention of being bullied into decreasing his parenting time with the minor child in exchange for leaving or any of that. There are no circumstances in this case. There was nothing attached to the motion. The only thing here is plaintiff's own desire to have him removed from the house immediately leading into the holiday season. I mean, come on. There's no circumstances, even alleging abuse. There's nothing. But without backing himself into a corner here, like Ms. Bryan suggested, he is willing to leave. He is happy to volunteer to vacate the home with the understanding that the temporary arrangement be preserved between the parties. He's happy to afford Ms. Campbell an expectation of privacy, but the understanding here would be that the status quo be preserved. my client is absolutely able to verify his position with regard to the status quo, with regard to the parenting time arrangement, and far more text messages than were included in my little sampling attached to the response. So I would request, if the court is inclined to do anything here other than maintain.
Well, she's super sad, Mikey, and super pregnant. Honestly, not a good combo. But these lawyers are arguing this very eloquently. I will say that. But Mr. Campbell has the added benefit of being a trained lawyer as well. So she's the odd person out here that's not a lawyer, and she's having a hard time maintaining her facial composure.
The shared caretaking arrangement that I had outlined and affirmed in a couple of text messages as a sampling, that we do a prompt and brief evidentiary hearing so as to demonstrate what the actual custodial environment for this child is before we enter a new order. He's had full weekends with the child alone, without issue, multiple weekends, not just one. He's regularly put her to bed during the week, admittedly, and as verified by Ms. Campbell's own correspondence. There haven't been issues with this. There aren't temper tantrums. There's no evidence of any kind of that. In fact, there's quite the contrary. If you skim the messages that I attached, there's affirmation that EJ is looking forward to seeing him, and she adores her time with him, and she's going to have a wonderful day with him, and has. But what's being proposed here is a drastic reduction from what the parties have been following. And more importantly, it's a drastic reduction from the schedule that's affirmed in Ms. Campbell's own correspondence to my client. Like I said, the ask here, consistent with the statute and the corresponding case law, would be a prompt and brief evidentiary hearing to demonstrate what the custodial environment is prior to making a drastic modification to it. And like I said at the beginning, the parties' allegations here really couldn't be further apart. But worth noting again is the reality that there's no evidence here to support Ms. Campbell's position, aside from the newly created calendar that was mentioned today. I have no evidence from this alleged PI. I have nothing. I have nothing aside from this oral argument to try and recreate history. So while I can very much see that Ms. Campbell is trying to blame my client for this divorce proceeding, it is wholly inappropriate to incorporate this minor child as leverage in that attempt, especially given her regular acknowledgement that Mr. Campbell is a wonderful father to her. Yes, he works full-time. Yes, he's moved on with his personal life and his own personal time that has been designated by the parties themselves as his personal time. But he has consistently prioritized his time with his child and very much wants to continue doing so. He has every intention of continuing to do so after the parties physically separate. He would absolutely maintain the position that he has served as a joint custodian to the party's child, and he only asked this court that he be permitted to continue doing so, consistent with the parenting time schedule that the parties themselves came up with and have been following quite literally for months. The comment about recently starting to pick the child up at daycare is significant because I would note again for this court that the child recently started daycare. She had an in-home nanny and her daycare didn't start until September. So yes, of course, he recently started picking up the child from daycare because it wasn't an option before. But the manipulation of facts here in an attempt to make him look like he has a selfish agenda is simply not accurate. So I would very much hope that the court would at least afford some additional time to get to the root of this established custodial environment if it's inclined to do anything aside from memorializing the shared caretaking arrangement. Thank you.
Ms. Bryan.
Your Honor, the shared caretaking arrangement is 1 hour on October 15, 1 hour October 17, 1 hour October 22, 1 hour October 24, half hour October 29. A few hours on a weekend here and there. He leaves early in the morning. If Attorney Judd wants to confirm that with her client, she could ask him that. He leaves early in the morning. He goes over to his girlfriend's. He's not there in the morning because he's with his girlfriend until the divorce case gets filed. And then all of a sudden he's hanging around a little bit more in the morning, kisses EJ in the morning, and then takes off. Now, the evening and what happened last night is not indicative of this great relationship that Attorney Judd claims that father enjoys with the child. The child runs up to mom. He didn't change her diaper, and he doesn't even stay around for the bedtime routine, instead preferring to exit before she even goes to bed. That is the facts of this case, and he can't get around it. So the reality here is that this case is not any different than what you hear on a Friday morning motion. We need to make a decision. I think it's clear based on the evidence the court has thus far that mom is the primary care provider for this child. She enjoys a close emotional attachment. She works part-time. She's devoted her life to this child, and father has devoted his time to his career and to his paramour, not to the child, and certainly not to Danielle. I'm glad to hear that Mr. Campbell's willing to move out. We would ask that it take place immediately. He hasn't moved out until now because he's trying to use it as leverage. But this is extremely painful for my client under the circumstances to see him exit every evening and head out to see his girlfriend, and then returning late at night, early hours of the morning, or whatever it might be. So we would ask that the court grant physical custody to mom and grant our relief and request with respect to parenting time. And this could be reviewed when we come back to the court for, settlement conference. So we could refer this to front of the court as well. Thank you.
Thank you. Well, based on
Sorry to interrupt you there, Judge. We're going to need you to shut up for a second. We're going to ponder this for a moment. Bear with me. Do it with me, if you will. You've heard as much as I have. How is this decision going to go? What will Judge McNabb decide? Will she side with the heavily pregnant wife with the sad, long face? Or will she side with Dad and his sassy new lawyer, who he works for a law firm? He's a lawyer. What do you think is going to happen here? Do you think it'll be a landslide one way or the other? Or is it going to be a little bit of a meet in the middle? A lot of judges that we see are really, they would be good mediators, and maybe they were, bringing people together to a point that works. But some judges, on the other hand, are a little more decisive. Get your votes in the chat now. Tell me what you think. And if you're watching this later, put your guess in the comments now. Pause the video. And, well, you can pause it now. We'll wait. And then we won't, just don't cheat. Okay? I think that also, don't Alex and Danielle look like just a pair? Their faces even look similar shapes. I don't get it. Anyways. All right, that's it. You can cement your thoughts into the chat, and then let's figure it out. Judge McNabb rules quickly.
both the written submissions of the parties as well as the argument today, it appears to the court that due to a number of factors, including the parties' relative work schedules, that the mother in this case does have the established custodial environment. That doesn't mean that father's not a good father. It just means that she is most likely the primary parent in this case, at least based on what I have today. So I will grant sole physical custody to the mother, joint legal custody of the parties. Parenting time would be alternating weekends with 2 overnights, and Wednesday evening or afternoon from 4 to 7 p.m. It sounds like the parties are agreeable to a status quo order regarding expenses, and the defendant is to leave the marital home on Sunday, November 24th, 2024 by 5 p.m. And after that point, the plaintiff is granted exclusive use.
Thank you, Your Honor. I'll prepare the order.
And
Your
I will refer this to the front of the court for.
Whoa, Sunday, November 24th. This aired today. This is a today hearing. That's in 2 days. That's very short. Isn't that? That seems very short to me. My goodness.
An investigation regarding custody, parenting time, and child support, and the parties are to split the fees.
Your Honor, I have a couple of clarifying questions, and then
Sure.
I did request a mutual civil restraining order in the motion. I assume the court has no problem with that.
I don't.
Okay, and then I guess I'm a little confused as to why my client wouldn't be permitted to continue a midweek overnight, especially if he is warranting that he has sufficient overnight accommodations. I also wonder if there could be a little bit of an additional time window on the exclusive use. Ms. Bryan herself indicated that for some reason her client believes that the place is available on December 1st. My client's father's home does not have a sufficient situation for him to immediately move into and have the same level of space there as a residence of his own would. So I would ask for a little bit of an additional amount of time for that. I'm not really clear here as to what the circumstances would suggest that we get 2 days, but that seems a little bit unorthodox, respectfully. I would ask for a little bit of an additional time window here, if that's an option for the court.
Father. Is that the Michigan way of saying of father? Father. I was trying to replicate it, but then she kept talking. But that word comes through very strong with whatever accent she has, Miss Stephanie. What is Miss Stephanie wearing below this area?
Well, as far as that goes, this is an unusual situation. I am taking into consideration the plaintiff's pregnancy and the fact that she's late in her pregnancy with the party's child, and the additional stress that this is causing. So I'm going to deny the request to extend that time. I see no reason why it couldn't be Sunday. And again, it's not a complete move out as far as having to, divide up personal property. Just sort of take your clothes, the things that you need, and then we can work out the rest of it going forward. And then as far as the Wednesday, I will allow an overnight for Wednesday.
Thank you, Your Honor. I appreciate that very much.
All right.
So we'll do the Friday daycare pickup, or I'm sorry, she's with Miss Campbell on Friday. So Friday, 4 p.m. start until Sunday. Is there an end time that the court would dictate here?
I think he goes to bed at 7:30, I think. So would
7
6
p.m.
o'clock be all right?
6 p.m. Is that what the court indicated?
I think so. Is the child's bedtime is 7:30?
I think that's correct. Danielle, can you nod your head? Yes, I think she
Okay.
said.
All right. I think 6 o'clock is appropriate for return.
Okay.
And then, Your Honor, with respect to the civil restraining order, I'm looking at her response. I don't see the request for the civil restraining order. I just, the whole issue here is how would that read? I think the whole, what Attorney Judd and I have discussed and what we've had a problem with is that we agree that neither party would disparage the other in the presence of the child or within hearing distance of the child. That makes sense to me, but I think he's trying to prevent her from having contact with her friends, some of whom work at the law firm where he is, and she should have free contact with him and be allowed to share, what she wants. I mean, they've reached out to her and are supportive of her. So what is the extent of the civil restraining order that the defendant requests?
Include a general non-disparagement clause as well as a restriction from interfering with either party's place of employment. I think that would be sufficient. I mean, my client's partners don't need to be hearing about this and wondering what's going on. I don't think that's appropriate. And I think that Ms. Campbell presumably has additional people she can confide in if she needs to vent about Mr. Campbell.
She's not had any contact with his partners, nor would she. nor would she interfere with his employment, but this is a court order. So I don't want to have some kind of misunderstanding that if she has a communication with a friend or supporter who's at that law firm, that that's viewed as being disparagement.
I think
And
it needs to be narrowly defined. I don't want to hash it all out right now, because it doesn't appear to be a subject of the motion, but I'll leave it to the attorneys to work that out. And if you can't, you can ask for a case conference with me.
Okay,
All right.
wonderful.
Okay.
Thank you, Your Honor. I'll prepare the order.
Okay, wonderful.
Thank you.
And we'll take
Have a
care
nice
of the referral to the front of the court.
Okay,
All
thanks
right,
very
thank
much.
you.
Okay, we're adjourned.
Wow, wow, wow. What an interesting case we came across there. I think that was not necessarily a split down the middle as I would think. I think the pregnancy card was played here very effectively. I mean, the late pregnancy card is, of all the pregnancy cards, very effective because it has a natural expiration date. Don't take that the wrong way. Anyways, let's watch one more little clip before we get going. I was able to get some court today, but I don't know what it is yet. So I always feel sorry for the kids. I feel sorry for the child in utero. I feel sorry for so many of them. But sorry, it's loud here. I'm gonna sneeze. Okay, hit the play button, Paisley. Holy shit. Judge Bromlick, save me! Oh, now I'm not gonna sneeze. You know when you can tell a sneeze is gone? Also, look at this cup on her desk. Is that a McDonald's cup? Have they brought back a retro cup? Or is that a replica of an old cup that's reusable?
Katie was having some audio issues, so she's going to be calling in if you could give her just one moment.
Okay, thank
Thanks,
you.
Stephanie.
Thank you, Stephanie. I know you're short down there this morning, but thanks for your assistance.
Not a problem, Your Honor.
Seriously, America, do the cups look
So I'll
like
just let
that
you know, my
now?
client is calling in. She was having some difficulty. She's at work and the internet is not great. So she's calling in right now. She just disconnected from the Zoom and she's calling into the Zoom phone number.
Thank you.
Catherine, can you hear us?
Yes, I can. Can you hear me?
Yes.
Much clearer than before.
Okay, good. I don't know why the internet's not.
For the record, this matter is before the court for final pretrial conference, as well as the plaintiff's motion for entry of a default judgment of divorce. This hearing is being conducted via Zoom. President Attorney Jason Kazmarek, representing the plaintiff, Catherine Dolman. Ms. Dolman, you are present on audio, is that correct?
Correct.
And sir, are you David Dolman?
Yes, I am.
Okay, Mr. Dolman, obviously you've not been participating in these proceedings. And if you had not appeared this morning, the court would have entered that default judgment of divorce.
Understood.
And did you receive a copy of that default judgment of divorce prepared by Mr. Attorney Kazmarek?
I did. Yes.
Do you have any objection to any provision contained therein?
I had previously asked both of them for two items that were part of our assets. And I was told no, she wouldn't consider that, unfortunately.
Right.
So
Again, the court does not have a copy of the proposed judgment, Mr. Kazmarek, so I don't know what two items that Mr. Dolman is talking about. Mr. Dolman, do you intend to hire an attorney, Mr. Dolman?
that is something unfortunately I can't do. And now I feel I'm kind of in a pickle because I was just told if I don't agree to this, the other attorney would be seeking fees from me. So
Essentially, the judgment, the party's been separated since December of 2016, so 8 years. Essentially, the judgment, I thought I provided a copy to the court that I was asking. I don't know how he
No.
didn't. But essentially, each party keeps what they have. No spouses board, each party keeps all the personal property in their own possession, their bank accounts, the retirement accounts, and keep their own debts. Essentially, everybody keep everything they've got, pay what they've got. Mr. Dolman had indicated they had bought apparently a singing bowl, and there's a rubbing, an piece of art.
I'm sorry, can you, what's the first item?
A singing bowl.
A singing bowl?
Yes.
Singing, singing bowl?
Correct. Correct.
What is a singing bowl?
Well, Your Honor, have you ever seen Beauty and the Beast? The best description of a singing bowl, I would say, would probably be in the realm of the Beauty and the Beast Disney movie, perhaps? I actually think it's probably some religious artifact that's metal that you like bring a stick around, and I probably sound like a jackass for joking about it, but I'm sure, actually I'm almost positive that is what it is. Like a metal bowl that you pull like a cauldron, but not. And they make weird sounds. Not like that, though.
It's used for meditation. It's just like a copper bowl that you rub a stick around and it makes a sound.
Okay, do you have that bowl in your possession, Miss Dolman?
Yes, it was a gift to me.
Okay. I'm sorry, David gave it to you as a gift?
Mm-hmm. Yes.
Okay. And what's the other item?
It is a rubbing, a temple rubbing that's framed.
I'm sorry, temple
Essentially,
rubbing?
if you have like a canvas and rub it against a rock and it appears underneath, it's a rubbing. It's a piece of art that's.
So I'm sorry, what's it called again? A temple rubbing stone?
Yes. Yes.
It's a piece of art. It's not a stone. It's a piece of art it's basically a piece of canvas. I understand. I think was put against the temple wall, rubbed against with I'm not sure, charcoal or whatever it was, and the artwork comes through from the temple. Is that correct, Katie?
Yeah,
Okay.
So
it's just a piece of canvas that's been rubbed through, so you can see what's behind it.
Okay. And Ms. Dolman has possession of both these. Mr. Dolman, you've been separated for 8 years. Why haven't you asked to return those in the last 8 years?
I've had so little contact with her. I don't know where she lives. I absolutely, sorry. I absolutely adore Katie from day one, and no one else could tell you any different. And you can still see how I am at this point. I have no idea why she decided to do this. She absolutely
Going out on a limb here, maybe it's because you're crying when you talk about this. I'm sorry, it's a bad joke. But 8 years is a long time. My ex-husband has remarried subsequently. We got divorced, or we separated the year before. And you know what? You just gotta walk away. My dude, you know what you do? You find you a new girl and you take her down to wherever the fuck you bought that bowl and that rubbing, and you buy one for yourself with your hot girlfriend beside you. And if you really like her, you buy her something too. But if you want that shit, buy it for yourself. Okay? Don't. Taking it from somebody else doesn't help. Move on. Come on now.
dropped everything, and unfortunately she's done that with a lot of things in life, and just decided she's just going on. And I kind of tried to keep myself in the picture for a while, and then she shooed me away because she knew I still had feelings for her. And I've had little to no idea where she has been, at least for the last 6 years.
Well, obviously, if these things were important to you, these two items versus property, you would have been able to track her down. But in any event, you're served with a complaint for divorce. Someone's a complaint for divorce back on September 26th. Why didn't you reach out then to her attorney? So these items I have no problem with the divorce. I just want these two items back. So you failed to, number one, you failed to answer the complaint. You didn't file a written answer. The sermon says you must file a written answer within 21 days. You didn't do that. The court then mailed out a notice for pretrial that you appear on October 4th. You did not appear. So, I mean, if these things were important to you, you would have appeared. You made the Miss Dolman's attorney jump through a lot of unnecessary hoops, Mr. Dolman. All you had to do was appear from day one and say, I would like these two items.
I can tell you, due to a medical condition, this is extremely difficult for me right now.
Well, you could have called in. It would take you 5 minutes. You could have filled out in handwritten form and answered the complaint.
I understand.
You've done nothing.
When this first, with the attorney, I emailed him and I explicitly told him if we could do this in different ways other than in this manner, because it would be very difficult for me. And I did state the items that I would like to have. And the reasons I'd like to have them are, unfortunately, I don't think they're going to be properly taken care of. And it's just her, I don't want to say behavior, but this pattern that she has shown over the years of just deciding on a whim to just stop this and sell all of this and move and do these things don't bear well for items that are very important. And it's not, I'm not being petty. I'm not being obstinate. It's just, I truly care about the provenance of this one piece.
Okay. Which one, again, if there's a trial, what the court would probably do, if you can't agree, the court would probably just liquidate it. Let's put it on the Facebook marketplace and sell them. Then it's much easier to divide cash than personal property.
Well, Judge, not only that, what he's concerned with was a gift. It was a gift. I mean, so I don't think it's even marital property. It was a gift.
Right. So, can the parties? So they can't agree. Can one party take one item and the other party the other item? Is that possible, Mr. Dolman and Miss Dolman?
At this point,
I offered for him to have the rubbing. I collect singing bowls. I was homeless for 4 years. In the last 8 years.
That's not relevant. It's not relevant.
And I've taken care of those items
Dolman?
because that's how much they mean to me. I'm sorry.
So you're willing to give him what, the singing bowl or the rubbing stone?
The rubbing.
Okay. What about that, Mr. Dolman? Just each split up. You can get the rubbing stone canvas. Miss Dolman would retain the singing bowl. And how much? What's it worth? Can you replace it?
It is irreplaceable, and it is something that just needs to know what the value is, unfortunately. But this is just, especially hearing what I just heard, which I did not know she was homeless for 4 years. I don't know. You did. It's just.
Did you want to talk? The two of you want to talk to see if we can work through this morning? We can put you in a breakout room. The three of you can talk.
Let's just get it done, whatever needs to be done. And Katie, I'm
going to put you in a breakout room, and perhaps you and Miss Dolman, since you've had no contact in the past 8 years, maybe the two of you can talk, and maybe you can understand what each party has gone through in the past 8 years and currently. And maybe after the two of you were married for 14 years. So I'm going to put you in a breakout room, give you about 5-10 minutes, see whether you can come to your own agreement.
No, emotionally, this is not good for me at all.
Mr. Dolman, you've got to participate. You want a trial date?
I'm saying,
first of all, you need to file an answer to the complaint, Mr. Dolman. We can't, there are court rules. And if you are ignoring these pleadings, you need to hire an attorney if you can't do it yourself.
I just said, do whatever she'd like to do. This is too emotional for me. I don't want to go to a breakout room and discuss it with her. Whatever she'd like, that's fine. I just implore her to think twice about that item in the future.
Well, the two of you can always talk in the future. She can always change her mind. You don't want to talk to her any further this morning. Is that correct, Mr. Dolman?
I would rather just have this finished.
You'd rather have it what, fixed?
Finished.
Finished. Okay. Mr. Dolman, again, do you have, did you receive a copy of the proposed default judgment of divorce from Mr. Kaczmarek?
Yes.
Okay. And you've had a chance to go through that?
I have. There was just one thing, because I don't know anything about these things. Just if there was something on here about like pending domestic thing, and I was concerned. I didn't know if, that couldn't be involving me. I don't understand that.
I don't understand either. I don't in front of me, Mr.
I think
Kazmarek, do you know
he's
what
probably
he's talking
talking,
about?
I don't think he's talking about the judgment. I think he's talking about the summons that said there was a prior action where my client filed in 2016 that was dismissed because she couldn't serve him. I think that's what he's talking about, which he may not be aware of that.
So, Mr. Dolman, look for a document that says judgment of divorce at the top. It's probably about 4 pages, Mr. Kazmarek, 5 pages?
That's correct.
Okay, Mr. Dolman, do you see a document that 4 or 5 pages that the first page is titled, probably in capital letters, judgment of divorce?
Yes, I do.
Okay, you received that. That was mailed out to you on October 28th. So that's the document that Mr. Kazmarek is asking the court sign today. That's the document that actually divorces you and Catherine. So go through that. I'll give you time if you need this morning to go through that with Mr. Kazmarek.
No, it's fine. I'd asked some simple questions and I didn't have answers to before, but at this point it's moot.
Well, go ahead. I'll try to answer your question, Mr. Dolman.
They were previous. I'm good now. I just would like to end this. I'm fully agreeing to this. Just if we could move on.
Okay, so you have no objection in the court entering this judgment of divorce to this morning?
I do not.
And again, obviously, apparently there's a provision that says each party shall retain the personal property currently in their possession. That means whoever, if Catherine has possession of this singing bowl and the temple rubbing stone canvas, she keeps those items. And whatever you have, you keep.
That's fine. I can't save those items. I can't help them. It's unfortunate.
Well, you can always reach out to Catherine after we're done, and maybe she'll change her mind if you can convince her it's that important to you. But again, Mr. Dolman, you have no objection. Is that correct to the court entering this proposed judgment this morning?
I do not.
All right. All right.
I can go through those terms quickly, Judge, if you'd like. I mean, I don't know how I swear I gave a few copies. The clerk may have them in a bin downstairs. I don't know. I'm waiting for this to happen. I'm not sure, but
we deliver the original in sometime later today then, Mr. Kazmarek?
The judge is a sadist, allegedly, in my opinion. He just wants to drag this poor guy through the mud. They have a more complicated divorce than some people that have children, NPC. Thank you so much. Look at that. $10 super chat. You're so great. Thank you. Streamlabs, you've been very good today. I may as well have jinxed it.
I will do that, yes.
Right. All right, Mr. Kazmarek, why don't you go through the terms briefly for the benefit of both parties?
Gentlemen, my phone just hit 10% and it just beeped at me. So I'm not sure if
I will be quick.
Necessary. Okay.
Can you plug it in? Can you plug it in, Mr. Dolman?
This would take me a few minutes to go find the parts.
So I'll be quick. So regarding spousal support, there's no spousal support awarded. Restoration of former name, Catherine will be given her former name of Green. There's no real estate. Regarding personal property, each party keeps whatever property they have in their possession. In addition, specifically, defendant will keep a Lincoln MKZ. Plaintiff has a 2025 Honda CRV, which is a lease. Each party keeps their own bank accounts. Each party keeps any retirement accounts in their own name. All parties retain any interest in life insurance. Each party be responsible for their own debts in their own name. Each party be responsible for their own attorney's fees. Essentially, that's it, Judge. I mean, that was just very basic. Each party keeps their own thing.
All right, let's update the proofs. Mr. Dolman, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Yeah, I do.
Ms. Dolman, you previously testified in the court established jurisdiction. Can you once again state your name for the record?
Catherine Ann Dolman.
Ms. Dolman, you previously testified that lived in the county of Monroe, state of Michigan prior to filing this complaint, that there, again, there were no minor children born during your marriage, correct?
Correct.
Pregnant.
Correct.
Ms. Dolman, are you currently pregnant?
No,
Necessary question. Once again, has there been a breakdown of your marriage relationship with David that the bonds of matrimony have been destroyed and there's no reasonable chance of reconciliation?
yes,
So if the court were not to sign this judgment today, would you go back and live together with Mr. Dolman?
no, oh, no,
Okay. And you're asking the court to sign and end this judgment of divorce, correct?
yes.
All right, Mr. Dolman, can you please state your name and current mailing address for the record?
David Dale Dolman, 9420 Van Antwerp Boulevard, Wright, Michigan, 48116.
Thank you. Mr. Dolman, did you hear the testimony of your wife, Catherine, this morning?
I did.
Is her testimony true and accurate to the best of your knowledge?
Yes,
Okay. Do you have any questions for the court or any questions for Attorney Kazmarek?
I do not.
And once again, Mr. Dolman, you have no objection to the court signing this judgment of divorce today. Is that correct?
That is correct.
All right, Mr. Kazmarek, do you have any questions of Mr. Dolman?
I do not.
All right, based upon the testimony that's been presented today as well as previously on October 4th, the court again finds that jurisdiction has been established and that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There's no reasonable chance of reconciliation. Accordingly, upon receipt of that judgment, court will sign the judgment, and at that time, the court will order that the marriage between the parties be dissolved and judgment shall enter granting a divorce from the bonds of matrimony. Right, Mr. Dolman, the court's gonna, Mr. Kazmarek gonna get that original judgment to the court today. I'll sign that. A copy will be mailed to you. So you'll get that in the mail next week, but that will conclude this matter. We can both zoom out, have a good rest of the day, and perhaps you can, two of you can communicate. If it's that important to you, emotionally, Mr. Dolman, maybe Ms. Dolman will have a change of heart and we'll give you those items. But per this judgment, they're in her possession, they're warded to her. So good luck, Mr. Dolman. Thank you for finally appearing. Now we'll conclude this matter. You can zoom out and have the rest of the day.
Thank you.
Welcome.
Judge is like, Freaky Friday. I want somebody to get fucking laid.
I'll just make a note. I'll just make a note of his father, Dolman, appeared.
Are we all just gonna sit in silence? Look at her McDonald's cup. Is that now? Is it old? Is it reusable? Tell me.
Okay. Oh, the child support rack. The 9:30.
They're just coming in now.
Right.
They need a child
Yeah,
support
yeah.
record?
I mentioned that to you yesterday. They got consent judgment, but it doesn't make reference to child support. I did. I told you that yesterday. Dubois.
Can you both hear me?
Yes, I can hear you.
Yes, I'm here.
Okay.
The courts have received a proposed consent judgment, but it does not address child support. Are you going to reserve child support, or do you want the front of the court to provide a recommendation this morning?
I would like child support. I just wasn't able to get
Okay.
his schedule and payment.
We can't leave that provision blank. So we're gonna put you in a breakout room with the front of the court. They will discuss with you your respective incomes and recommend an amount. And hopefully you can both agree upon, we can attach that to the judgment of divorce, okay?
Okay.
Yeah, that sounds fair to me.
You can join the breakout room.
I don't know. They freeze in weird positions. Little Creed frames for us all. Let's see if I have when they came back. I may just fucking have it. Look at me being a real YouTuber.
have Celeste Du Bois versus John Du Bois.
For the record, this matter is before the court for a pretrial conference. The same is being conducted via Zoom. It appears that both parties are present. How do you pronounce your last name? Is it Dubois or Dubois?
It's Dubois.
Dubois? All right, Celeste Dubois is present, and also John Dubois the third is also present. Good morning, both of you.
Good morning.
Two of you have conferred with the front of the court this morning, Ms. LaPrade, and she's provided the court with a recommendation that commencing January 1st, 2025, that the defendant John shall pay child support through the Monroe County front of the court for the benefit of the minor child of the parties, the amount of $620 per month. You both understand that?
Yes.
Yes.
Right, and you're both agreeable with that amount, is that correct?
Yes.
Mr. Dubois?
I have no choice, so yeah.
Well, you do have a choice. It's based on your incomes. Now, the spousal child support can go up and down over the years. Obviously,
Yeah.
it's all based on your income. For example, if you get laid off, you want to file a petition to reduce your support or abate it. If Miss Celeste gets a better job and she got more income,
Well,
then obviously you can
I
file
do
a petition
plan.
to change. Hold on, you can always modify child support. So as right now,
Okay.
this recommendation is based on your respective incomes through 2020.
Yeah, that's fine then.
It's all controlled by guidelines. So if in fact, when you say you don't have a choice, you do have a choice, Mr. Dubois. If in fact they're using incorrect income for you, and you're saying perhaps maybe Celeste has got a side job where she's being paid cash, $1,000 a week. I mean, obviously you want to include that.
Right.
But otherwise it's based on your reported income.
Hold on, Judge. Do you have a link to that side job that pays $1,000 cash a week for me, please? Allegedly? I'll take that number. Come on now.
And also the number of overnights does have a small bearing on that. This recommendation is based upon you having 75 overnights. If in fact you had more parenting time and you were watching them, it was like 50-50, then obviously it would affect child support a little bit.
Right.
So again, based upon your current status, are you agreeable that the court will adopt this and enter this order of $620 per month commencing January? Mr. Dubois?
Yes.
All right, and same with you, Mr. Dubois, you're also agree with this on for the time being?
Yep.
Yes.
All right. So this will be attached to your judgment of divorce, which both of you have approved. Can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony you're about to give this matter will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Yes.
Thank you. We'll start with you, Miss Celeste, since you're the plaintiff. Can you please state your name and current mailing address for the record?
My current address is. Oh, I'm sorry.
Please state your
My
name.
name is Celeste Dubois.
Address?
Michigan 48101.
48101?
Yes.
Okay. Mr. Dubois, is it true that you filed a complaint for divorce with this court on or about September 6, 2024?
Yes.
Is it further true that on the date you filed that complaint, you'd lived in the county of Monroe for at least 10 days and the state of Michigan at least 6 months?
I live where?
On the date you filed that complaint, namely September 6, 2024, is it true that you lived in the county of Monroe for at least 10 days and the state of Michigan at least 6 months?
Yes, yes.
Is it further true that you married John Dubois on April 13, 2019? You separated in October of 2023?
Yes.
Is it true there's been a breakdown of your marriage relationship to the extent that the objects of matrimony have been destroyed? There's no reasonable chance that your marriage can be preserved?
Yes.
Is it true there's only one child born during your marriage, namely Luna, who's still a minor?
Yes.
Were there any other children born or adopted during your marriage?
No.
Are you currently pregnant?
No.
Did you sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
Okay. Mr. Dubois, can you please state your name and current mailing address for the record?
My name is John Joseph Dubois III. My address is 4. I apologize. It's trailer 16.
That's Flat Rock?
Yes. Yes, Your
Thank
Honor.
you. Mr. Dubois, did you hear the testimony this morning of your wife, Celeste?
Yes, that's correct.
Was your testimony true and accurate to the best of your knowledge?
Yes.
Did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes.
I'm going to walk through this judgment with both of you. You've agreed that the two of you should share joint legal and joint physical custody of your daughter, Luna, which is wonderful. It's wonderful. You can co-parent. She will thrive and do well if you're both on the same page for her benefit. So communication is the key. The court has checked a couple of boxes, which you did not. This is required by law that if both of you must notify the other and in front of the court of any change of address for purpose of communication and parenting time. And neither of you shall remove the child from the state of Michigan without the consent of the other parent or the approval of the court. With respect to parenting time, your judgment says the child will live with mother for majority of time. Father will keep child every other weekend, 2 nights. Father will have unsupervised visitation through the weekdays. If in fact there's an issue about parenting time in the future, either one of you could file a petition with the court, motion with the court asking for a specific schedule. So obviously this schedule that you got here is pretty general. It requires effective communication in terms of who's going to pick up, who's going to drop off, where you're going to meet, and so forth. Fortunately, you do not live very far apart between Flat Rock and Allen Park. Child support, which was not addressed. I'm going to check the box at child support. Shall be pursuant to the Uniform Child Support Order, which is incorporated into this judgment divorce, and that's will be attached, $620 per month. So that will ultimately come out of your paycheck, Mr. Dubois. You need to pay that directly to the front of the court, and they keep all the records. Pay that to the front of the court until you see it coming out of your paycheck.
One more time, Your Honor.
You need to pay that child support directly to the Monroe County front of the court until you see it coming out of your paycheck.
Okay.
Beginning in January. You've spousal support is not awarded. It's forever barred. You've already divided your personal property, so each keep the personal property current in your respective possession. There are no joint debts, so each pay any debts in their own names. Each will keep their own automobile and pay any debt they're on. There's no real estate to be divided. And further, there's no pensions or retirement plans to be divided. And Miss Celeste, you're going to keep your name of Dubois. Is that correct?
Yes.
Okay.
Yes, Your Honor.
All right. Do either of you have any questions for the court?
No, Your Honor.
Okay. There's one last issue I just want to address. In the state of Michigan, there's a statutory 6-month waiting period in any divorce case in which there's a minor child, just to make sure there's no chance of reconciliation. In the 6 months, begins to run the date you filed the divorce complaint, which is September 26th. So in your case, the 6 months expires on March 6th of 2025. The court does have the authority to waive that waiting period. And the court would do so if you both agree that it's in the best interest of your daughter to finalize things so you can move forward with your lives. So Ms. Celeste, are you asking the court to waive the waiting period and enter judgment of divorce today?
Yes, please.
You believe that to be in the best interest of yourself and your daughter to finalize things sooner than later?
Yes, Your Honor.
Mr. Dubois, same question to you.
Yes, Your Honor.
All right. Very well. The court appreciates your cooperation in submitting the proposed consent judgment of divorce. Based upon the testimony that's been presented this morning, as well as complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Accordingly, it is ordered by this court that the marriage between the parties be and is hereby dissolved, the judgment shall enter granting a divorce from bonds of matrimony. Further, the court assigned the judgment. You both mailed a copy of this, and now we can conclude this proceeding. You can both zoom out. Have a good rest of the day, and good luck.
Thank you.
So are we divorced now and we're just
Yes.
waiting for the paperwork? Okay.
You are
Thank you, Your
divorced.
Honor.
The court signed the judgment today. You both have now the copy.
Okay. Thank you, sir.
Okay.
You're
Thank
welcome.
you so much. Thank you, Your Honor.
Welcome.
Awkward.
So we just leave? I'm sorry. I'm just making sure. Are we?
Yes, you can. We're done. You can hang up.
Okay.
Let's see that, please. 2 copies, please. Thank you.
They were just doing paperwork. It's over now. She was sitting there. He was gone. He needs to wash his phone. Everybody needs to wash your phone. This is a good reminder to do that. Wash it up. Wash it up. Lucy, thanks so much for the tip. I did manage to get that today. Do rewind and watch it with us. It was quite the case. I think that case went in a different direction than I thought it was going to. But damn, it made for a good case. And I'm sure we will see them back in court as we go forward. I have to go to the gym before I can eat my pizza that I want to eat tonight. So that's on my agenda. I hope you guys have more fun planned for your Friday night. But don't worry, I'll be back tomorrow. We'll be live again tomorrow. So keep an eye out for it. That wife was a doctor? Really? Now, that doesn't make any sense. Because I thought she was a stay-at-home wife. So, with a part-time job. They didn't say she has a part-time job on ER. Like, huh. But she did have that very serious, I've learned a lot of shit face. All they said was she worked part-time. They didn't specify. Also, I mean, can she, I guess in America they just send you right back to work? Anyways, I'm joking, guys. See, here, if you have a baby, you got a year off. Your job's not really a concern for a year. Anyways, it's too late here for the gym as well, Bev, but that doesn't excuse me from having to do it. I have 2 hours. Anyways, remember, guys, I love you, and I'm proud of you, and I will see you in the next video. That's tomorrow. Bye.
Ways down and ready to